Hi friends, welcome to the NPTEL course Strategy and Technology, a Practical Primer. We are in week 9 with the theme of Technology as Strategic Driver. In this week's lecture, the 44th in this series, we will discuss the topic of technology and patenting. We have seen earlier that creation of intellectual property is one of the most important planks of competitiveness. Technologically developed countries such as USA, Japan, Germany, South Korea and Taiwan have high R&D spend. High R&D spend is a marker of the technological innovation that could take place in a country. We have given here 30 countries which have good R&D expenditure levels. The table has the country R&D expenditure in terms of USD billion, purchasing power parity, percentage of GDP and R&D expenditure per capita. You will notice that countries which are known to us as developed have high percentage of GDP in terms of R&D expenditure. They also have high R&D expenditure per capita. We have countries such as USA which are scoring on both these parameters. So did South Korea. We also have Taiwan at 3.5% of GDP, which is amongst the highest, and 1,822 of per capita R&D, again one of the highest. That probably explains Taiwan's lead in some technology-led industries such as pharmaceuticals and semiconductors. Canada, despite being a developed country, is rather low, which speaks of its dependence on other countries, particularly other developed countries, for innovation. Germany has high per capita spend and also high percentage of GDP. Japan is one of the highest again, 3.2% of GDP in respect of R&D expenditure and 1,375 R&D expenditure per capita. China is picking up 2.2% as GDP percentage and 368, which is rather low in terms of R&D expenditure per capita. India still has certain miles to go. India's R&D expenditure as percentage of GDP is only 0.7 and R&D expenditure per capita is also just 40. So we need to have several other steps before we can become technologically innovative in terms of the R&D expenditure marker. Let us look at the other countries. The European countries, particularly Netherlands, Sweden and Israel, have good R&D expenditure per capita and also high level of R&D expenditure as percent of GDP. Israel, which is known to be one of the more innovative countries, has 4.9% allocated out of the GDP for R&D expenditure, and its per capita R&D expenditure is also on the higher side. Singapore's per capita R&D expenditure is on the higher side, but as percentage of GDP, it's somewhere in midway. European countries, as I said, Denmark, Finland, Switzerland, Austria, Belgium, Netherlands, Sweden rank high in terms of both the parameters. It is therefore important to note that the countries need to invest in R&D expenditure in proportion to the GDP and in alignment with the population, so that there is an impactful R&D in the country. We in India need to do something more to be able to reach the benchmarks that we have. Why do we do R&D? We do R&D to create intellectual property, and intellectual property is of different types. Generally we hear about only patents, but there are several other forms of intellectual property that are of importance. World Intellectual Property Indicators 2020 talks about several IP systems that are available for protection of intellectual property. The most known, that is the patent. This is a set of exclusive rights granted by law to applicants for an invention that meets the standards of novelty, non-obviousness and industrial applicability, generally valid for a limited period, 20 years. Utility is a different kind of protection. Like a patent, a utility model confers a set of rights to an invention for a limited period, during which time the rights holder can commercially exploit the invention on an exclusive basis. Utility models are issued for a shorter period, 6 to 10 years. Trademark is another intellectual property protection that is well known. This is a sign used to distinguish the goods or services of one enterprise from those of another, and this is protected as an intellectual property right. Trademarks can be registered for both goods and services. Unlike patents, trademark registrations can be maintained indefinitely as long as the registration is renewed based on the national and international laws. Another aspect of intellectual property protection is the industrial design. Industrial designs are applied to a wide variety of industrial products and handicrafts in terms of shape, color, etc. The holder of an industrial design has exclusive rights over the design and can prevent unauthorized copying or imitation of the design by others. Plant variety is assuming significant importance. To obtain protection, a plant breeder must file an individual application with each authority entrusted with granting the breeder's rights. A breeder's right is granted only when a variety is new, distinct, uniform, and stable, and has a suitable denomination. GI or geographical indication is interesting. It is a sign identifying a good as originating in a specific geographical area and possessing a given quality, reputation, or other characteristic essentially attributable to that geographical region. Thus, the main function of a GI is to indicate a connection between the quality, characteristic, or reputation of the good and its territory of origin. India has asserted recently several geographical indication rights for some of its unique products. The last one is the appellation of origin. An appellation of origin is a special kind of geographical indication. The most important difference between appellations of origin and other GIs is that the link with the geographical area should be stronger in the case of an appellation of origin. In other words, the appellations of origin are a more restrictive subcategory of GIs. Depending upon the products and services we deal in, and depending upon the kind of intellectual property we have used to develop those products and services, we can seek an appropriate form of intellectual property protection. For commercialization, patent is the most impactful intellectual property protection, followed by utility model and industrial design. Worldwide patent applications relating to computer technology still accounted for 7.3% of all published applications in 2018. That is the latest year for which complete data became available with WIPO. Among the top 10 technology fields, machine tools plus 11.7% increase, other special machines plus 11.4%, and chemical engineering plus 11.4% witnessed the fastest average annual growth between 2008 and 2018. The slowest growth is that of computer technology and medical technology. Much more information is available in these slides. You can certainly go through once again. The data trends indicate that the conventional electromechanical and chemical domains continue to witness intellectual property creation, even as the newer digital and biological fields became large creators. Patent origins and field distributions. Data on origin of patent applications and domains of patent application provides additional insights. In 2019, an estimated 1.5 million patents were granted worldwide, up 5.5% on 2018 figures. China issued the highest number of patents in 2019, 452,804, followed by US 354,430, Japan 179,910, the European Patent Office 137,782, and the Republic of Korea 125,661. India moved up 3 spots to 7th position in the ranking, while Germany remained in the 9th position. China and US are heavily filing in computer technology, Japan and Korea in electrical machinery, France and Germany in transport. Switzerland and the UK filed heavily in pharmaceuticals, the Netherlands in medical technology, and the Russian Federation in food chemistry. Applicants residing in India, 18.1% of the total published applications, and Mexico, 9.9%, filed most heavily in pharmaceuticals. Therefore, there is a kind of country relevant skew in terms of the preference for different fields amongst different countries. There are certain specializations by regions in specific domains and consequent changes in ranking. If you look at the patents in force globally, we have 3.1 million patents in force as of 2019, followed by China 2.7 million, Japan 2.1 million, and the Republic of Korea 1 million. Interestingly, more than half of all patents in force in the US originated from non-resident applicants. This has been so because of the attractiveness of the US market opportunity on one hand and the lack of national patent infrastructure in other countries. That is the twin factor set that influence this. In contrast, in certain countries such as Japan and South Korea as well as China, the bulk of patents were attributable to the resident applicants. Therefore, the essence is that if you have good national patent infrastructure and if the market opportunity is large, many resident applicants would come up to file patents within the country. As I said earlier, patent rights generally last for up to 20 years from the date an application is filed. An estimated 14.9 million patents were in force across 127 jurisdictions in 2019, representing an increase of 7% on 2018 figures. It is not enough if we file for a patent, pay the fees, defend the patent application and get the patent. We got to pay the maintenance renewal fees periodically so that the patent does not lapse. Although the patents can be maintained for 20 years, the average age of patents varies across offices. This fact suggests that not all patents ensure long-term commercial or competitive potential. Just because you have a patent, it doesn't mean that you have a marketable opportunity. A marketable patent strategy must form an integral part of technology and business strategies. In the utility model area, China has got significant upward movement. As I said, a utility model is a special form of patent right granted by a state or a jurisdiction to an inventor or the inventor's assignee for a fixed period. And the protection is for 12 years compared to 20 years of normal patents, and the eligibility requirements are less stringent. In 2019, the total number of utility model applications reached 2.34 million, up 9.1%. In that, IP Office of China accounts for the most dominant share of 96.9%. All the other 79 offices accounted for just 3.1%. In some countries, utility models can be applied for in the same fields of technologies as patents. In other countries, utility model protection is eligible only for the shape or structure of the products in certain fields of technology, such as mechanical devices and apparatus, but not for technical, chemical, and biological processes. Eligible subject matter for utility models varies significantly from one country to other. Interestingly, such countries as US do not grant utility patents. In practice, protection for utility models is often sought for innovations of a rather incremental nature, which may not meet the patentability criteria, which is non-obviousness as well as novelty. Industrial design is the ornamental or aesthetic aspect of an article. An industrial design may consist of three-dimensional features such as the shape of an article, or two-dimensional features such as patterns, lines, or color. In industrial designs, there has been a steady increase from 2005 globally. And in China, there has been a rapid increase over the years, whereas EU took the mid position. Between 1883 and the early 1950s, the offices of Japan and the US averaged similar numbers of applications, rarely exceeding 10,000. But the Office of China began receiving applications in 1985 and has seen unprecedented growth. And Republic of Korea surpassed the Office of Japan in 2004 and has remained in second position ever since. Therefore, in respect of industrial design, certain countries have taken the lead over these years because these are useful for companies to establish and protect the unique designer language of their products. You may not have patent for the entire product, but at least you can have the protection for the kind of design which you have uniquely imbued into the product. The unique profiles of certain automobiles and devices come under this category. Trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks are protected by intellectual property rights. To obtain trademark protection in multiple countries or jurisdictions, applicants can either file their applications directly at each individual office known as the Paris route, or file an application for international registration through the Madrid system, the Madrid route. In 2019, the Madrid system came into being and afforded trademark holders the ability to obtain protection for their branded products and services in an area covering a total of 122 countries. Here again, China has been growing substantially in terms of trademark applications. It is an exclusive right to the use of the registered trademark, and it implies that others cannot infringe on the trademark and make it appear as though the product of the competitor is the same as yours. It reinforces the right of the innovator legally. Plant variety applications have become extremely important but also controversial. There is a convention called the International Convention for the Protection of New Varieties of Plants, CPVP. It is an intergovernmental organization set up to essentially protect the interests of corporate plant breeders. Since the so-called Green Revolution in India, there has been talk of breeder rights in the country. But India has stood steadfast in not joining the convention. This is because the plant breeder rights it prescribes severely limit farmers' freedom. Farmers are the backbone of the Indian economy. Their rights have to be protected. Therefore, India would like to accelerate its own research into development of new plant varieties so that the country can protect and grow its agricultural heritage in a contemporary manner. Geographical indications, they do not really confer any right of commercialization, but it reflects on the quality, reputation, and other characteristic that is essentially attributable to that geographical origin. The basmati rice of India, certain herbs which are relevant for the Indian soil and the Indian nativity qualify for geographical indications. Germany had the most GIs in force in 2019, followed by China, Hungary, the Czech Republic, and Italy. Given that we have got several products and natural varieties of geographically unique nature in our system, we can do this protection through a variety of legal means, sui generis systems, trademark laws, regional system, international agreements, and other national legal means, etc. Then there is this creative economy. Creative economy is nothing but the global publishing industry that caters to educational and non-educational segments, including the children's books. And it is not a small economy either. The 21 countries that shared data with WIPO generated a combined revenue of $67.3 billion in 2019. You would have seen in many books the ISBN mark. The ISBN is a permanent international standard book identifier assigned to a publication and administered by the International ISBN Agency. ISBN data does provide a good indication to the size of the publishing market. The US, with 5.2 million registered ISBNs in 2019, was by far the biggest user of ISBN identifier in 2019, followed by South Korea, Germany, China, UK, Italy, and the Russian Federation. Print editions generated more than 3/4 of trade sector revenue. Japan leads with 30.4%, Sweden 28.8%, and Finland 26.8%. Again, creative economy is something where India can really shine, and we need to put more efforts in generating creative economy that is reflective of our talent to write and communicate. So having seen the picture globally in terms of these different types of intellectual property protection, we should really look at the processes of patenting. Just to recall, a patent is a form of legal protection by the governments provided to the owner to exclude others from making, using, selling, and importing an invention for a limited period of years. Patenting really helps firms, more so the startups, protect their innovations and achieve competitive advantage. Patenting is usually based on prescribed criteria such as novelty, usefulness, and non-obviousness. National governments have their own patent offices to examine, grant, and publish patents based on fulfillment of the prescribed criteria. Under the World Trade Organization's TRIPS agreement, patents granted in one state should be available and respected in the member states. India was recognizing only the process patents in the 1970s, but when it became a signatory to the World Trade Organization's TRIPS agreement, India started respecting the product patents as well. There are, of course, certain leeways to get the patented products into the country, such as compulsory licensing, when the country faces unusual public emergencies. There do exist variations on patentability and exemptions across member nations, especially relating to the domains of public health and social good. Patenting creates monopolies in certain industries, especially in pharmaceutical and biotechnology as well as electronics industry, and therefore it is a major driver of intense startup activity in such domains. Startups particularly would do well to focus on patenting from the very early stages of their ideation and prototyping activities. What are the steps involved in patenting? First of all, we should prepare a patent application. And we have to decide as applicants whether the product, the process, the theme we have is worthy of patenting. Therefore, we have to take decisions as applicants on the patentability and the type of patent required. Then we need to file with the patent office. We have to choose the right patent office to file and the patenting route. We'll talk about that later. Then the patent office examines in a formal manner the patent application. There will be initial maintainability and admission. There could be certain technical reasons and certain very obvious ways of looking at the patent. Then the patent will be published after a certain period of time by the patent office, and anyone who wants to object saying that it is not meeting the criteria of patentability can raise their objections. Then, working with the patent office, the applicant has to defend the patent as required, and once that defense is considered appropriate, the patent office gives the grant of patent, and granted patent needs to be maintained. This is the general patenting process, which is elaborate and requires very specialist officers, including techno-legal people, to be able to fulfill this process. In this patenting search is a critical step. First, you need to know the prior art that is existing in the industry. You also need to understand the state of the art in terms of what could probably move as a patent application. So we have to brainstorm based on the key terms for patent search. We have to search the international patent databases to list potential relevant patents and the prior art. We have to download the relevant patents and examine them in detail to determine any infringement that our product and process could have, and that would determine the patentability of the innovation. Take independent legal opinion on the patentability, because the lawyers who are specialized in intellectual property defense can look at the problem without bias and from an independent point of view, and they understand the nuances of protecting intellectual property. And in the event of any doubt, we must engage a legal attorney to undertake an in-depth and comprehensive review so that we get a complete independent opinion. We also have some public databases which we can rely upon: Google Patent Search, US Patent Database, and other international databases. We can search patents based on the following resources. I have given this listing so that you can, at your convenient time, look at least one or two of these portals and understand the kind of information that is available in terms of patents. All this is from the US Patent Office. US, the single largest market, is a focus of global inventors, and the United States gives 4 types of patents. 1. Article of manufacture. 2. Composition of matter. 3. Machine. And 4. Method or process. The article of manufacture patent protection is given for those novel products with new uses produced for the first time. Composition of matter is given when it is an intermixture of 2 or more products creating a new material with properties not possessed by the base materials. Machine, a device that is not a mere aggregation of known components and devices and delivers a novel function. Method or process is a series of novel steps to manufacture a product, novel or established. Patent Cooperation Treaty is a very convenient way of addressing international patent applications. The Patent Cooperation Treaty, or the PCT as it is typically referred to, came into existence in 1970. It is open to states that are party to the Paris Convention for the Protection of Industrial Property that was entered into as early as in 1883. PCT streamlines the initial filing process, makes it easier and initially cheaper to file a patent application in a large number of countries. When we develop a product, we are not very sure in which market we will be really marketing it. However, we would like to protect it all across the nations. And to make several hundred applications is just impossible for any country, even for a large country. And it's also impossible for a company. Therefore, PCT comes into being. PCT provides a path to seek patent protection for an invention simultaneously in every country that is a member to the treaty. An international patent application under the PCT route may be filed by anyone who is a national or resident of a member country. The special appeal of the PCT process is that it enables the patent applicants to file a single patent application and have that single uniform patent application be treated as an initial application for patent in any member country. That is the advantage. So you don't have to file 100 patent applications. You file one patent application and later on choose in which countries you would go for national applications. Filing an international patent application under the PCT route starts the patent process, and it can be started wisely and before anyone else can try to secure the patent rights. And it secures your own patent rights in multiple countries. Obtaining international patent protection is not cheap. Therefore, we should understand that every international patent application cannot mature into an international patent. A common international patent does not exist legally, which is one of the factors that causes international protection to be quite costly. PCT process in that context provides a golden mean. It enables a national stage for filing a patent application, claiming the benefit of international patent application directly in a particular country within 12 months of filing the international patent application. However, we must seek patent application protection in each country because individual countries issue their own national patents. The international PCT process is a very convenient uniform process that allows applicants to start on the road of patent protection in any number of jurisdictions without the need to make a priori decisions on which countries to file and in which markets to market the product. This is a great advantage. The general popularity of PCT is attributable to 4 factors. PCT is cheaper to initiate compared to filing in every member country. The latter would be very expensive in the aggregate. PCT allows up to 30 months to actually decide the countries where the inventor wants to receive the patent. It also allows the inventor to decide later after the invention and the market has developed and matured. Yet, if the inventor is sure about the target market, it would be worthwhile to target only that market for the patenting. Let's say your business strategy is that you would operate only in the United States. You should focus only on the United States patenting. So PCT is useful when you still have certain decisions to make, when the markets are yet to mature and you have your own strategic considerations that need debated. PCT also has a set of information sources, just as USPTO has. I have listed these databases here. And as of today, the PCT has 153 contracting states or member countries. In India, the patenting process has refined itself over the last several years. We can file the patent application with the Indian Patent Office in any of the branches, Delhi, Mumbai, Chennai or Kolkata. The patent application can be filed as a provisional application or as a non-provisional application with the Indian Patent Office, and it is linked to the PCT. Patent filing and grant procedures are broadly the same as those that are followed internationally. India is a member country of PCT, therefore it is also a receiving office for international patent applications under the PCT route. So if you make a provisional application in India, that is tantamount to making a PCT application internationally. And within 12 months of the filing, we have to make a complete specification. There are 6 different kinds of patent filings that are allowed in the Indian Patent Office. These are A. Ordinary application, B is PCT national phase application, PCT international application, conventional application, divisional application, and patent of addition application. Startups certainly need patenting. Patents help a startup protect its intellectual property and create a monopoly. You don't have to show a lot of revenue. If you have patent estate, which is very protective of your product idea, your prototype, and its way of performing in the market, then it could generate huge value for the company, and companies may be tempted to acquire the startup to integrate with their own mainstream intellectual property. Patents also protect startups against theft of inventions and poaching by established and emerging rivals. Patents enable R&D and joint venture partnerships. Hero MotoCorp has entered into an alliance with Ather because Ather has patentable electric vehicle technology. Patents enable valuation and venture capital investments. Patents are also a powerful reason for high-value acquisitions. When you have a strong patent base, startups can make a huge IPO effort, and the IPO proceeds would be based on significant commitments by international investors for companies which are patent protected. There are several instructive cases of patent importance. Amazon obtained a patent in 1999 for its one-click online purchase system. Within 23 days, Amazon filed a patent infringement suit against its then larger competitor Barnes & Noble, the physical bookstore company, over the latter's use of a similar system. The judge granted an injunction ordering Barnes & Noble to stop using Amazon's one-click system, giving Amazon the edge in online book retailing. After that, Amazon became an undisputed leader in online book retailing. Intellectual property protection through patenting, coupled with innovative business model, leads to business dominance. Patenting should be based on 2 criteria. 1, we should be the first to preempt competition, and we should be the best to build a business model that can be built around the patent. We have another example of Google. In 1998, Google deemed its seminal PageRank patent number 6285999 so vital that it filed for it before it had a business plan, venture funding, or even a domain name. Google paid Stanford University, to which the patent had been assigned, $336 million in shares to exclusively license the patent to it. Without that patent, said one analyst, Google would have been trampled by copycat search engine offerings from Yahoo, Microsoft, and other big players who once dominated the market. Google's dominance in search and its consequent emergence as a tech giant is now history. That said, as a startup becomes the dominant leader, it could be prone to innovative challenges. Patent again should be based on 2 criteria: foundational patent and an expanding patent estate. We have considered 2 other patent criteria before, and now these are 2 other criteria which we should keep in mind while developing a patent strategy. Another instructive case of patent importance is that of Fractus SA. Carl Spunte, a 2014 finalist in the European Inventor Awards, invented a mobile phone antenna based on the principles of fractal geometry, which allowed the mobile phone to be much smaller. But his Spanish startup Fractus SA could not possibly manufacture enough fractal-based antennas for the 1.5 billion smartphones sold each year. Thanks to its patents, however, Fractus was able to license its technology to 90% of the world's smartphone makers. Imagine the kind of business that this particular patent generated for Fractus. Patents were very important to us, the founder says, not only in protecting our innovative technology, but also in expanding our market share. Practice patenting is a case of patenting helping in R&D partnerships and licensing. This is a win-win situation whereby the inventor maximized its revenues without huge additional investments, and the industry benefited without painstaking time and efforts to discover new patentable hardware. It was a kind of platform invention that was available, accessible for a license fee for the entire industry. Patents also generate a lot of legal battles. The case of Honeywell, Nest and Google speaks of that. Shortly after intelligent home product startup Nest introduced its first product, a smart thermostat, it was hit by a patent infringement suit from the industry giant Honeywell. Nest began patenting its innovative products and eventually would own several hundred patents and patent applications to defend itself. Nest also acquired 60 third-party patents relating to its product line from the patent aggregator Intellectual Ventures, which helped buttress its IP position. If Honeywell's goal was to litigate its upstart rival Nest out of business, Nest's patents made it impossible. Nest's patents were also a key attraction in the company's eventual acquisition by Google. Patenting helps firms not only defend themselves and grow, but also allow themselves to be acquired on their terms. Patents are very important for IPOs. The tech giant Facebook was in for ripe IPO situation, but Facebook felt that it didn't have the patent estate that would mark up the IPO to a much higher level, which it really deserved. So, even though it was a tech giant, Facebook felt the need, when preparing for its IPO in April 2012, to shell out $550 million to buy 650 former AOL patents that were owned by Microsoft. That was in addition to 750 patents Facebook had bought a month earlier from IBM. The purchases were partly a response to a then pending Yahoo patent suit against Facebook, but experts say Facebook's larger objective was manifold. One was to reduce investor concerns over Facebook's legal risk in advance of its IPO. The other was to protect itself against further litigation down the road, given that patents are increasingly the weapons of tech company competition. Law firms in the West have huge stakes in legal battles related to intellectual property protection. Even the smallest of infringement can be identified, tracked and fought bitterly till one of the parties wins or they make a settlement so that they don't spend much more money on the legal challenge. Twitter made a similar patent purchase from IPO shortly after its IPO. Patent IPO is very well connected. Patent portfolio must be strengthened before an IPO is launched. It also boosts business growth. Patents can help a startup launch a billion-dollar empire. As IP Folio Chief Executive Rupert Mayer observed, patents have helped at least 10 major startups launch multi-billion-dollar enterprises. Some examples are Dropbox Network Folder Synchronization Patent, Zynga's Asynchronous Challenge Gaming Patent, Square's patented system and method for decoding swipe card signals, GoPro's patented harness system for attaching a camera to a user, Google's breathtakingly valuable original PageRank patent, which I have already referred to. And more cases of this nature are there, which were so vital that the owners of those patents boosted their business in an unprecedented manner. There are several instructive cases of patent importance which lead us to certain conclusions. The 2008 Berkeley research project, Patenting by Entrepreneurs, an empirical study found that 67% of the venture-backed startups reported that patents had been vital for them in securing an investment. While 40% of all startups held patents, 80% of those receiving venture capital finance owned patents. According to a 2014 National Science Foundation-backed study, 49% of manufacturing and service firms have used inventions obtained from external sources to develop their most important new products and services. And again, in 14% of these cases, the source was a startup. In many cases, the patents on those startups' inventions served as the legal scaffolding or the legal protection around which joint ventures and research and development partnerships were constructed. In another 2015 study, Patents, Innovation and Performance of Venture Capital-Backed IPOs, the authors found that patents strongly and positively predict the long-run performance of VC-backed IPOs. Indeed, VC-backed IPOs with patents substantially outperform other VC-backed IPOs. The same holds true even for non-VC-backed IPOs. Another study, 2007 study on patents and the survival of internet-related IPOs says that firms without patent protection are much less likely to survive. Patents are therefore important for startups to ground themselves very strongly and grow. We have a case study here of CRISPR, one of the most important innovations that has occurred in the biology field or the sharper genomics field. Genome editing has taken the genetic world or the biological world by storm. Changing a DNA sequence in a living cell is known as genome editing because not every gene of an individual is perfect. Not every gene of every individual is perfect. The genomes are also responsible for certain chronic diseases and certain susceptibility to diseases. So genome editing is considered one of the recipes for disease prevention and disease curing. Genome editing has been extremely challenging for a long time. CRISPR-Cas9 has made this process easier. CRISPR is a bacterial immune system that has been repurposed for making precise breaks in DNA. Scientists use Cas9 protein to slice the DNA sign into two. The cell will die if it does not repair the damage to its genome. So it has two main ways to fix the DNA break, which is explained in the next slide. CRISPR, whose expansion is clustered, regularly interspaced, short palindromic repeats, is a family of DNA sequences found in the genomes of certain organisms such as bacteria and archaea. This is the graphical illustration of the working of genome editing technology. Although our interest as part of this is not to dwell deep into the biology of it, what is important for us is that something which is never understood in the previous decades is now fully understood. Scientists use the CRISPR-9 system to make a precise cut in an organism's DNA. The cell repairs the break in its genome through an approach that scrambles the DNA sequence left or by patching the break with a new piece of DNA designed by the researcher, which is the right. So you can introduce a donor DNA of choice and get a new DNA formation, removing the bad part of the DNA which you don't want. So scientists can keep a harmful gene from working or add in a helpful sequence to the gene. So in the pathway shown in the left, bits of DNA are inserted or deleted at the cut site before the free DNA ends are reattached. When a gene sequence is disrupted in this way, it will no longer function. So this is a great way to stop the effects of a harmful gene. In the alternate pathway shown on the right side, researchers add a piece of DNA containing sequences that match the site of the break, and the cell uses it as a patch to repair the cut. In this way, scientists can deliver new genes with useful functions or replace a mutation with a healthy sequence. So two purposes. One, the harmful gene is stopped in its track and deleted out of the DNA. It is made dysfunctional or non-functional. Whereas in the other approach, which is also part of this gene editing, you get a healthy gene, a donor DNA of choice, and get the entire DNA reconstructed the way it has to be functional to our satisfaction. That is the principle of genome editing. These are some of the graphics relating to how Cas9 acts, how the guide RNA works, how the repair enzymes come in, and how the inserted DNA shapes up. With the rapid development of life sciences, genome editing technology has become the most efficient method to study gene function, explore the pathogenesis of hereditary diseases, develop novel targets for gene therapy, breed crop varieties, etc. They have become the most favorite genome editing tool in molecular biology laboratory. The genomic tools have made numerous achievements in the field of correcting pathogenic mutations, searching for essential gene for cancer immunotherapy, and solving key problems in organ transplantation. Even though there are some limitations, Many innovations have taken place so far, and some of these are listed below. There is also a base editing system which improves the Cas9 system. This is again a matter of detail which I am leaving with you for more detailed study based on your interest and based on your time convenience. David Liu is an American chemist and biologist who has been at the heart of Cas9 system by phage-assisted continuous evolution, which can recognize multiple PAMs. Many innovations took place after that, and by using these Cas9 variants, researchers have repaired some previously inaccessible disease-relevant genetic variants. Then there is also the RNA editing. Compared with DNA editing, RNA editing has the advantages of high efficiency and high specificity. It can make temporary reversible genetic edits to the genome, avoiding the potential risks and ethical issues caused by permanent genome editing. At present, RNA editing has been widely used for preclinical studies of various diseases, which opens a new era for RNA-level research, diagnosis, and treatment. Even the COVID vaccine development is based on mRNA development, wherein the RNA is taught to fight the vaccine, create antibodies, create helper cell stimulations in the body. CRISPR-Cas9 will drive the genomics market, and millions of dollars that could accrue through this new technique is stupendous, and it will offer new approaches for modification of genes, and the whole emphasis is on modifying erratic genetic diseases for our betterment. 3 areas: diabetes treatment, oncology treatment, and agricultural development. These are the 3 very important areas where CRISPR has already shown its mettle, and the future is promising. CRISPR is already a very powerful tool, and many individuals are working on it with several other genome editing systems, and this domain will continue to improve and it will be differentiated. The innovation of CRISPR will continue to be differentiated with more genome editings coming into play. The practice of using CRISPR to correct disease-causing mutations is also growing. So, genomic editing as a fundamental platform innovation is one, but application of this genome editing to different diseases is another scope for innovation. The genome editing wish list includes also better methods for multiplexing, that is, editing more than one gene at a time. This is also a future that is very exciting. As a result, the startup activities in CRISPR have grown by leaps and bounds. I have talked about some startups here: biomedical R&D, agricultural biotech, industrial biotech, and biological R&D. Funding also has been growing substantially. Biomedical R&D has received 73% of funding, whereas industrial biotech 10%, biological 5%, agricultural biotech 5%, others 7%. Funding for CRISPR has grown by 70% over 4 years, 2016 to 2019. And the annual funding also has been very good. These are the companies which are listed by and large in the USA and 1 or 2 in Switzerland, and which have gone to IPO as well, and their funding has been substantially of high standard and high level. These are the top funded CRISPR startups which are into different fields such as natural and synthetic nucleases, plant breeding, genetic engineering solution, transformative medicines, xenotransplantation, and cardiovascular and coronary artery diseases. These technological developments indicate that technology, particularly the life experience technology that I have talked about earlier, life modifying technology is going to be the core of sunrise technologies, and they are going to dictate new business strategies and new business models in the area of healthcare. These are the keynotes relating to this topic, and you can please go through them at your convenience. Thank you for your attention. We will meet again in the next lecture.